And because this labor unfolds in fiction aimed at young adults, the hermeneutics become not only thinkable but feelable. Young adults' narrative technique translates theological and juridical argument into affective stakes. Readers don't receive egalitarian interpretation as abstraction. They rehearse them by inhabiting protagonists who negotiated contract, challenge exclusionary pratic, or claim authority traditional than to them. This matters especially for young readers encountering this question for the first time, and for readers in context where overt feminist theological argument is polished or inaccessible. I track a free design site across recent young adults fantasy by Muslim women, juridical design, so contract, oaths, court protocol, and so on. Authority architecture, who may interpret, heal, or lead. And finally, cosmological ethics, non-gendered source of power. These are the building blocks of legal design on the page. Let me return to that hospital science and unpack how narrative history function in practice. Nairi, the protagonist, is in a precarious position. She is a mixed blood herself, Shafit, but she's also the last living Naid, the only one who can heal with magic. So the royal family neither skill, but the Daev aristocracy is deeply invested in maintaining blood purity hierarchies. She has leverage, but only if she uses it strategically. So she negotiated. She don't make a speech about equality. She write it into the contract. The hospital will receive funding, royal backing, if it admits Shafit patients, if it hires Shafit staff. The institution is redesigned at the level of its eligibility rules and its governance structure. What marks this narrative is to heed. First, it's juridical design and interpretative work. The contract don't argue that Islam demands egalitarian access to medical care. It builds a system when egalitarian access is structurally embedded. The word building does the interpretative labor. The storyboard text as alternative. What if institutional mechanism redistributed power? Second is affective. We experience this shine through Nairi focalization. We feel her calculated risk, her awareness that one misses could cost everything, her determination to protect the vulnerable without openly defying the aristocracy. The ethical stakes aren't abstract, they're embodied in her negotiation. Third, it's legible within genre. This is a fantasy novel. Palace intrigue, magical politics, an heroine leverage her unique position, all standards young adults moves. But the content of that negotiation is feminist hermeneutic work, redistributing authority, challenging blood-based hierarchies, insisting that care is right, not a privilege. This sham perform what Islamic feminist scholars like Ziba Mir Hosseini describe as reinserting woman's voice into process of religious knowledge making. But it does so through fictional institutional design rather than exegesis. And because it's fiction, it's reach readers who might never encounter Mir Hosseini's work. Readers who are learning what egalitarianism Islamic ethics might look and feel like through Nairi's story. Popular young adult fantasy is infrastructural. The novels are on Amazon, are on Kobo, and circulate through Goodreads, BookTok, Book Club, social media, platform where interpretative communities assemble transnationally, when young readers debate juridical details in common threads, where they rehearse arguments about gender and authority. By making interpretative labor feel like adventure and justice at once, the stories create a condition under which feminist ethics become desirable, not just theoretically defensible, but emotionally compelling. This novel don't replace the work of Islamic feminist scholar, of course. They accompany it, building effective infrastructure through which feminist ideas reach youth public. Narrative instead is so interpretative labor at the level of word making, its performance affective word that complementary scholarly Islamic feminist. Thank you for your attention.
Now I would like to call Mr. Mohammed Mishal. Uh, Mohammed Mishal, if you can unmute yourself and present your paper, please.
Hi, hello, can you hear me?
Yes, yes, we can. Please present your paper.
Okay, just a minute. Firstly, sorry for some technical issue. Good evening, everyone. Uh,
Good
in
evening.
this
Good
today
evening.
modern world, one of the most debated subjects in discourse by Muslims and non-Muslims alike has been the place of women in Islam. While Islam was revealed as a liberationist message that uplifted women from the oppressive customs of pre-Islamic Arabia, later historical developments saw the emergence of patriarchal interpretation that often undermined the Quranic spirit of justice and mercy. Looking at historically, Sharia was never meant to be a system of male authority, but as a divine gate for promoting human welfare and preventing harm. Now, the universal principles of Maqasid al-Sharia or the higher objectives of Islamic law, which guarantee the preservation of life, intellect, religion, lineage, and property equal for men and women, placing both as a vicegerents upon the earth. Yet, patriarchal interpretations, influenced by cultural, political, and colonial pretexts, have curtailed women's contributions in legal, intellectual, and public spheres. And this paper seeks to transcend patriarchy by re-espousing the integral position of women in implementing the aims of Sharia. By re-examining spiritual evidence and classical scholarship as well as contemporary reinterpretation, it will be shown that the idea of gender justice is not an imported concept, but it is, in fact, it is inherent in the very divine intent of Islam itself. Second, let's check out the theoretical framework of Maqasid al-Sharia and gender. The concept of Maqasid al-Sharia, the higher purpose or intents of Islamic law, was most systematically developed by the classical jurists like Al-Ghazali, Al-Shatibi, just like that, some scholars. And they identified five essential objectives under these Maqasid al-Sharia. The protection of religion, life, intellect, lineage, and property. In Arabic, we will say hiful din, hiful nafs, hiful aql, hiful nas, and hiful mal, respectively. Later, the scholars like Ibn Ashur and contemporary reformists like Jas Rauda have extended these objectives to include justice, dignity, and freedom as overarching principles. In a sense, the maqasid represent the moral and ethical soul of Sharia, which is guiding the law toward universal human welfare. Most importantly, these objectives are gender neutral and they protect the well-being of all members within the community. Therefore, not including women in this would go against the very spirit of the Islamic Sharia. For an instance, hifun nafs, which means the protection of the uh, body. Uh, the hifun nafs protects each and every individual's dignity and safety, irrespective of the gender. Hiful aql promotes the acquisition of knowledge. which is a duty upon all Muslims, including men and women, as stated in well-known hadith, which is seeking knowledge is obligatory upon every Muslim, including male and female. The next one, Hifun Nasli, which upholds the moral basis of family and spouses, uh, uh, not especially not male superiority. Just all those systems approach to the maqasid emphasize flexibility, dynamism, and centrality to human dignity. In this perspective, we can see that the empowerment of women is less a modern innovation than the restoration of Islam's moral bearing. When women are deprived of their agency, justice as a basic maqasid falls closer. The next, historical and spiritual foundations. The Quran repeatedly proclaims that the equality of men and women in spiritual, moral, and social responsibility. Verses of Quran 9.71 says, the believing men and believing women are allies, which means awliya of one another. They enjoy what is right and what is forbidden and what is wrong. This verse establishes the partnership, not the hierarchy. Similarly, Quran, the verses like 33.35 list men and women together across 10 categories of virtue, promising equal reward and accountability. The first human story in Quran, we can see that the first human story in Quran also renounces the patriarchal being. Both Adam and Hawa are addressed equality in their error and repentation, putting them on an equal footing of mutual moral responsibility. In prophetic practice, women are clearly agents of the nascent Muslim community, just like Khadija bint Khuwailid radiallahu anh. Besides being the spouse of Prophet, was his financial and emotional supporter during the time of revelation. And like Aisha bint Abu Bakr, uh, went, went on to become one of the greatest scholars of hadith and jurisprudence, transmitting over 2,000 of narrations. The next, Salama, she participated in legal reasoning and political advice, famously influencing the strategic decision of Prophet, peace be upon him, at Hudaybiyah. And women also engaged in governance and education. The Caliph, the Khalifa Umar appointed Al-Shifa bint Abu Abdullah to the position of supervisor of the marketplace in Medina, effectively an inspector of public ethics. Such examples indicate that the early Muslim society didn't restrict women to the private sphere. In fact, uh, the marginalization of women is not an Islamic inevitability but a later socio-cultural distortion. The Quran and Sunnah provide the basis for such leadership of women in scholarship and public contribution. So, let's check out the patriarchal interpretation and their impact. Uh, so, while the revelation of Islam was revolutionary in its affirmation of women's dignity, the later centuries saw a gradual re-entrenchment of patriarchy in Muslim legal discourse. Many factors contributed: tribal customs, male dominated scholarship, political centralization, and colonial intervention. Many of the classical jurists lived and worked within a patriarchal social system that was reflected in their ijtihad, or it means legal reasoning. For an example, restrictions on women's testimony or leadership were often based on conventional social practice rather than on overt spiritual prohibition. This interpretation gradually solidified into orthodoxy, which positioned male dominance as divine will. So this was further complicated by colonial encounters in which our European powers generally represented Muslim societies as inherently misogynist. And the result of this was defensive traditionalism on the part of Muslim scholars, which only produced rigidity, a retreat into literalism that equated gender equality with westernization. Now, the patriarchal readings even obscured the maqasid of Sharia, instead laws that was supposed to protect women, such as in regard to inheritance or marriage, were interpreted restrictively. The emphasis went from justice and welfare to control conformity, thereby women's access to education, religious authority, and public decision-making declined. Here, the recent feminist hermeneutics, especially Islamic feminists like Amina Wadud and Asma Ballas, have resisted this imbalance. The They have they have our advocated for a Tawhidic paradigm that is read in the Quran through the unity and justice of God, thus negating all forms of domination, including male supremacy. Uh, their approach resonates with Maqasid Sharia as a return to Islam's ethical source, namely the equality of all humans under divine sovereignty. The next, woman as central actor in the objectives of Sharia. Recentering woman in the objectives of Sharia calls for a movement from token inclusion into active participation. Women are not beneficiaries of the law; they are co-agents in realizing its purpose. The first one in religion and knowledge. We can find that Hifluddin, it involves not only personal piety but also the transmission and interpretation of religious knowledge, from the jurisprudential contributions of Aisha to the founding of Qarawiyyin University by Fatima al-Fihri. Just like women have always protected the religious intellects of the Ummah, the community. Uh, so the female scholars and muftis of today's Egypt, Malaysia, and Indonesia do the same when they issue fatwas and practice public theology. The next one in life and welfare, their role in life and welfare. Women's leadership in health, social services, and education directly fulfills hifzun nafs. During the Prophet's time, there were women like Rufaida al-Aslamiyya who served as medical workers on the battlefield. Modern Muslim women also further, not only the during the Prophet time, the modern Muslim women also further this goal through humanitarian work and in advocating for victims of violence and poverty. Next, we have their role in intellect and education. The Quran commands reflection, tafakkur, and the pursuit of knowledge. It is in direct opposition to hiful aql, to the new woman of education. Intellectual empowerment of women by institution upholds the spirit of Islam more than institution that exclude them. In family and lineage, hiful nasl, the family and lineage. It is not just biological but moral and spiritual, and it regards equity, consent, and compassion with marriage and family life. The Quran describes marriage as a relationship of tranquility, love, and mercy. We can see this in the Quran, implying partnership rather than domination. And next, in property and economic rights, from very early in Islam, from very
Hello,
early.
I'm sorry to intervene, but you have to wrap up in another 1 minute, please.
Okay. Sorry for so I will conclude here the by saying the object. So, as a conclusion, the objectives of Sharia justice welfare, dignity, and compassion cannot be achieved under a patriarchal system that marginalizes women. Islam's revelation entrusted both men and women with the responsibility to develop moral order and social justice. This is further evidenced through the repeated pairing of male and female believers as the partners in virtue in the Quran. To transcend patriarchy, the Muslim community need to re-engage in maqasid sharia as living framework responsive to human realities. So some of I'm gonna conclude. Sorry for uh, such technical issues in the starting. Thank you. That's all.
Okay, thank you, Mohammed Shal, for your presentation. Now I would like to invite Dr. Samana Oladi to come and present your paper.
Thank you so much for the invitation. Can I share a slide with you all? Is that okay?
Yes, yes, please.
Okay, wonderful. Give me 1 second. Well, before I'm just going to share it very quickly, but I do want to thank the organizers of this conference for a very, very important and timely sort of subject. So it's a pleasure to be here. I will be sharing my slides and I'll begin shortly. Okay. All right. And so my presentation today is going to be talking about basically reclaiming the sacred, right? And this is, I'm looking at faith-based feminist or women's activism within the context of Shi'i Iran. And this is sort of part of my larger book project that looks at Muslim women's religious authority, Muslim women as agents of change, and how they utilize basically their faith to advance gender justice within their own setting. So to begin, I do want to say that this project itself, it sits at the intersection of Islamic studies, feminist anthropology, and the main question I'd like to ask is, how do Muslim women in Iran, right? We're talking about a Shiite Muslim majority context. How do they engage with religious tradition to challenge some of the reform and try to reform some of the more patriarchal and hierarchical structures? Now, in order to explore this, I want to take you guys back to a journey. I went back to Iran. I remember this was in 2006, and I visited my childhood friend. Her name was Layla. And when I told her about my research project about Muslim women, women's activism, she was very skeptical, right, about my research on women's rights and religious reform. And she warned me. She said, be careful not to be misled by the idea of liberating Muslim women. She said, we don't need more Westerners, because she knew I was in the West, I was in America, I was studying here. She said, we don't need more Westerners telling us to or wanting us to be saved from our culture or our religion. She saw my work, my project, part of a long legacy of Western cultural dominance, like outsiders imposing their assumptions on Muslim women's lives. And she reminded me to remain critical of the Western gaze that too often basically casts Muslim women as victims needing rescuing. Now, 2 years later after this encounter, I saw her again. This is in 2008. And this time she was in a state of despair. She was very upset because her husband of 14 years had entered a second marriage. And he tried to justify this by saying that it's permitted in Islamic law. For Layla, it felt like a very deep betrayal. And I remember she asked, how can I maintain my faith, right, when I see such injustice carried out in the name of my religion? Now, what she was trying to do was she was trying to and she came from a sort of a conservative background as well. She was trying to reconcile her faith and justice. So what she did was, instead of abandoning her religion, she joined an organization named Itilaf Islami Zanan, which means Islamic Women's Islamic Coalition. This is an organization that uses faith-based activism to advance women's rights within Shia Iran. And she was not alone. A lot of Iranian women, rather than turning away from their religion because of some of the laws that tend to be discriminatory, they try to engage with it. They try to reinterpret it and they try to draw on its teaching to argue for gender justice from within the tradition. Now, this raises a lot of, I would say, questions, important questions. So, for instance, why did women like my friend Layla and a lot of other women who were in the organization, Etilaf Islami Zanan, why did they come to see sort of how did they come to see reform within Islam? And why did they believe that this was the most effective path towards justice? And my other question was, can Islamic law itself be shaped or reshaped or reformed from below? Now, to understand the activism of these women, we must basically really try to understand these women's lived realities. Scholarship on Islam and gender, a lot of times we see that they often privilege or only focus on doctrines, right, texts, over practice. What happens is that they overlook how faith is embodied, how it's negotiated, and how it's reimagined in daily lives. And for these women, religion is not a fixed code, but it's a moral field where interpretation itself becomes an act of resistance, right? And their activism is grounded in context and in experience. And for them, the main point that they're trying to make is that Islam and gender justice are not opposing forces, but they can coexist through reinterpretation that's rooted in ethical commitments. All right. Now, since the basically, since I would say maybe a couple of 4 or 5 decades, a lot of early 2000s or so, you have a lot of Muslim writers and scholars who have been debating about women's rights within Islam, right? But a lot of their discussion has centered on secular feminist movements. So faith-based activism, a lot of time has been sort of sidelined or ignored, and there's a gap in understanding of how Muslim women use or influence religious thought, social policy, and legal reform in Muslim majority contexts, in particular within the context of Shia Iran. A lot of scholarship on Iran looks at sort of secular women's organization. And there's also this sort of a binary in public discourse. There's one narrative that claims that religion limits women's rights, and there are others that insist that no, religion grants them freedom and it's very liberating. Both of these points of view overlook something that's very important: the role of Muslim women themselves, how the roles that they play in shaping religion and the state itself. And so my project, or this paper, basically tries to challenge these binaries by focusing on Shia women's activism in Iran and trying to find out how their engagement with Islamic jurisprudence reshapes both gender norms and sort of religious authority. Now, the point is rather simple. So the dominant narrative, whether it's like, they portray Muslim women as victims of orthodoxy or like revolutionary feminism, right? These are very sort of extreme polar perspectives, in my opinion. What they do is that they flatten the complexity of faith-based activism, and these women are neither sort of simply sort of agents of patriarchy, nor secular reformers. They occupy a dynamic space between these two. And by framing Muslim women as either basically bound by or liberated from religion, we erase the agency to act through.
Ma'am, you have 1 more minute to wrap up.
Oh, okay, rather than against it. Thank you. So one of the things that they do is they utilize what I call women's jurisprudence. This is a central concept, and in Farsi, it's called fiqh zanan. This frame work reinterprets Islamic family law through women's experience and insists that gender justice must be central to religious law. For centuries, Islamic jurisprudence was developed almost exclusively by men. The resulting interpretation reflects male perspective on basically marriage. And sort of family law in general. Women's jurisprudence tries to correct this sort of an imbalance by engaging directly with sacred texts. These female activists try to redefine the interpretive tradition itself. They employ Islamic principles of ijtihad to revisit religious rulings and examine whether they align with Islam's sort of overarching moral commitment like justice or compassion. And in this process, law becomes dynamic rather than static. These activists involved in these organizations, or the ones that utilize fiqh zanar or women's jurisprudence, combine ijtihad with hermeneutic phenomenology, right? And so in a way, they are trying to approach law as lived experience rather than abstract doctrines. And this allows them to situate legal interpretation within women's real lives, not just male-centered theories. And with that, I'm going to conclude my talk. Thank you.
Thank you, Dr. Samana Oladi. It was such a wonderful presentation. Thank you so much. Now I would like to invite Mohammed Arif. Please present your paper. Mohammed Arif, please can you unmute yourself and present your paper?
Thanks. Hello, dear dignitaries and my dear friends. I am Muhammad Arif K, studying at Darul Huda Islamic University. The topic of my research paper is Integrating Gender Justice and Islamic Family Law, a comparative study of social traditions and judicial transformation in contemporary Morocco and Indonesia. The reform of Islamic family law represents one of the most significant areas of legal scholarship in contemporary Muslim societies. Family law plays a critical role in regulating the private sphere of life, particularly in areas such as marriage, divorce, child custody, and inheritance, and gender roles as a branch of law deeply rooted in religious tradition. In recent decades, the global discourse on human rights and gender equality has exerted profound pressure on Islamic legal systems to reinterpret traditional jurisprudence in ways that accommodate contemporary values. The legal framework governing family relation is largely shaped by Marriage Law Number 1 of 1974 in Indonesia, which reflects a synthesis of religious norms, customary practices, and state regulation. In Morocco, the family code known as Mudawwana al-Usra of 2004 represents a progressive context of the personal status law by aiming at enhancing women's rights and promoting more egalitarian marital relations. This paper is guided by the following research questions. How have Indonesia and Morocco reformed their Islamic family laws to incorporate gender-inclusive principles? And what are the similarities and divergences in the recognition of women's rights and gender equity within the two legal systems? The term feminism is often seen negatively and misunderstood. In post-colonial Muslim societies, including Egypt, feminism is stereotyped with enmity between men and the woman and call for immorality in the form of sexual promiscuity for women. Originally, the term feminism is derived from the French word féminisme. Similarly, in Indonesia, Retna Megawangi, for example, assumes that feminism oppresses the role of housewife. This assumption was rejected by Myra Darcy, that feminism is not against the role of housewife. Nextly, Indonesia's Marriage Law Number 1 of 1974 as a model for progressive reform. The development of Islamic family law in Indonesia represents a complex interaction between religion, colonial legacy, and post-independence nation building. Indonesia has long integrated Islamic norms into its social and legal frameworks. As the world's largest Muslim majority country, even though it is officially a secular state. The drafting of legal codes became a center of negotiation between Islamic scholars, secular nationalists, and local traditionalists. This period culminated in the enactment of Marriage Law Number 1 of 1974, which sought to harmonize Islamic principles with national legal standards. The Marriage Law Number 1 of 1974 remains the cornerstone of Indonesian family legislation. It was enacted to create legal uniformity across religious and ethnic lines, replacing the fragmented colonial legal system. The primary objectives of this law include ensuring the protection of women and children by promoting the welfare and stability of family life and preventing abortion or abusive practices such as unregistered marriage and uniterated divorces. It requires marriages to be registered with the state and introduce minimum age limits for marriage. The minimum age for marriage is 19 for men and 16 for women, though later amendments aim to equalize this. Mudawwana al-Usra, addressing the reform of Islamic family law in Morocco. The reform of Islamic family law in Morocco represents one of the most progressive and widely discussed examples of legal modernization within a Muslim majority society. The Moroccan Family Code, known as Mudawwana al-Usra, enacted in 2004, stands as a landmark in representing Sharia-based principles with contemporary notions of gender equality, social justice, and human rights. The Mudawwana introduced judicial oversight of divorce, ensuring that repudiation by men is no longer valid without authorization. These provisions restored a degree of procedural equality while preserving the Islamic character of martial discourses. In the Article 14 of Mudawwana al-Usra says that marriage is defined as a legal agreement where a man and woman jointly agree to unite in a standard and lasting married life to commit and create a stable life. This breaks the discriminatory tradition of equality between husband and wife and eliminates the woman's obligation to obey her husband. The reformed code enhanced the role of family courts as central institutions for implementing justice. Judicial oversight now governs all marriage, divorce, and custody proceedings by protecting women and children from abortion decisions. The code also introduced the principle of mediation before divorce by encouraging recolonization and the preservation of family stability. By institutions these procedures, Morocco moved toward a more accountable and based administration of Islamic family law. However, Mudawwana retains traditional Sharia-based rations, with males generally receiving double the family share. It also allows for testamentary freedom up to 1/3 of the estate, enabling families to mitigate gender disparities through private arrangements. The success of 2004 reform was due to the unique convergence of top-down and bottom-up forces. King Muhammad's leadership provided religious legitimacy and political cover for reform, while women's organizations furnished the intellectual and moral arguments for gender justice. 2 decades after its enactment, the Mudawwana al-Usra continues to shape Morocco's social fabric. It has improved women's legal literacy, expanded their access to justice, and encouraged greater public debate about the compatibility of Islam with human rights. Despite the tensions, Morocco's family law reform stands as a model for
Nabi, you
recognizing.
have to wrap up in the next 2 minutes. Thank you.
Okay. The Mudawwana al-Usra serves as both a legal and moral framework for reimagining gender relations within an Islamic paradigm of equity, dignity, and shared responsibility. The minimum age for marriage is 18 years for both men and women. Which this demonstrates as that divorce only valid before a court. Husband or wife may file must show reasons such as disharmony or neglect. Contrasting paths of reform in Indonesia and Morocco through Islamic family law. The reform of Islamic family law in Indonesia and Morocco provides us an illuminating comparative study of how two Muslim majority nations negotiate the relationship between Sharia and gender equality. Both countries have sought to reinterpret Islamic family law in light of modern realities. Yet, their trajectories differ significantly. Morocco's reform culminated in the Mudawwana al-Usra, characterized by an egalitarian vision of martial relations and judicial oversight, while Indonesia's marriage law number 1 of 1974 represents a more conservative accommodation of Islamic and customary norms by maintaining a partial family model. This chapter compares these two experiences across several dimensions by highlighting how Islamic family law adapts within diverse political and cultural frameworks. In both Indonesia and Morocco, the state's role in mediating religious authority has been crucial to reform the process. Yet the relationship between religious legitimacy and political sovereignty diverges sharply. In Morocco, the monarchy serves as the central source of religious and political authority. This dual legitimacy allowed the king to frame the 2004 Family Code as an exercise in ijtihad consistent with maqasid sharia, which means the higher objectives of Islamic family law by emphasizing justice, means al-adl, equity, means musawa, and family welfare, which means maslaha. Thus, the reform was presented not as a secular instruction, but as a religiously sanctioned reinterpretation grounded in Morocco's Maliki tradition. Both Indonesia and Morocco articulate their family law reforms through the language of Islam, yet their engagement with gender equality differs in depth and scope. The conceptualization of marriage lies at the core of each legal system's approach to reform. Morocco's model is egalitarian and Indonesia's is hierarchical. The comparative experience of Indonesia and Morocco demonstrates that Islamic family law is not static but adaptable to diverse socio-political contexts. Morocco exemplifies a top-down model
Please
of reform.
conclude your paper, Muhammad Arif.
Okay, as a conclusion, Indonesia represents a negotiated model by balancing Islamic family law norms, and Morocco exemplifies a top-down model of reform. And thanks for giving me a golden opportunity to present my paper in this topic. Thanks for organizers of Jamia Millia Islamic University under Sarojini Naidu Center for Movements. Thank you.
Thank you, Muhammad Arif, for your presentation. Now I would like to invite Dr. Seema Kazi to present your paper.
Thank you. I hope you can all hear me. Good
Yes,
evening
ma'am.
and salam to everyone.
Good evening, ma'am. Yes, we
I
can. You are
am.
audible.
I must apologize for the delay. I was commuting. I have 10 minutes as I understand. And before beginning, I'd like to thank Jamia and the Sarojini Naidu Center for Women's Studies and Amina, who facilitated my participation. Thank you very much. So what I'm going to do in this presentation is to present some thoughts regarding Muslim law, which is a very contested terrain, and which is not only the case in India, but I imagine in many parts of the world. So I want to begin by just making a conceptual clarification regarding the terms Islamic and Muslim. And here I think it's very useful if we can, conceptualize Islamic as the ideal and the Muslim as practice. So while the Islamic ideal is something to be aspired to, Muslims have different ways of trying to be, good Muslims and practicing the ideal. So what I think we can infer from this is that the conceptual difference between Islam and Muslim in terms of differentiating between Islamic canon and its very diverse Muslim interpretations. And this is related to what, my main question is about Muslim laws. And I talk particularly in the case of India and South Asia. So just to share these points with you, and perhaps we can have a discussion later. Historically, Muslim family law has been a contested marker of Muslim identity and Muslim difference, and it is widely regarded as incompatible with women's rights. There have been presentations before me regarding the Sharia and Islamic law. So what I want to just add here is that the Islamic law or Sharia was compiled during the 9th and 10th centuries by Muslim jurists. While the basis of the Sharia is divine, in that its principal source is the Quran, it has also simultaneously been subject to human reasoning and interpretation by Islamic jurists over the centuries. Differences among Islamic jurists in analogical reasoning has led to the evolution of four major schools of Islamic law. And here I'm talking of Sunni law, which is the four major schools are Hanafi, Shafi, Maliki, and Hanbali. A related point is that the jurisprudential difference among the adherents of different schools of law also resulted in varied legal positions for female conduct. And I think this is really interesting and very kind of germane to trying to craft feminist understandings of Muslim law. So, for instance, while all schools agree to the unilateral termination of marriage by men, women are entitled to judicial divorce under Maliki law. Maliki law allows a woman to petition not just on grounds of sexual importance, as in the Hanafi law, but also on grounds of desertion, failure to maintain her, cruelty, and her husband being afflicted with a chronic or incurable disease detrimental to the wife. In contrast, Hanafi law allows women to stipulate conditions in their marriage contracts, which is the case in India and perhaps in South Asia also, although it permits polygamy. The other three schools consider both conditions unacceptable. Now, these varied interpretations on women do not reflect any frozen, definitive model of future family relationships for Muslim women. Rather, this interpretative diversity illustrates how the Sharia has been subject to human reasoning and interpretation at different historical periods in varied political, social, economic, and cultural settings. The Sharia, we can say, therefore, is a historically conditioned document, combining both divine revelation and human intervention. It was never intended to be a blueprint for all future Muslim societies. Once this point is appreciated, it is possible to argue that the different interpretations of the Sharia reflect the constant flux in historical conditions. As is perhaps well known, there have been few women interpreters in the history of Islam because women are seen to be the subject of Islamic Sharia and not its legislators. In the absence of female theologians, of which again I heard mention of Amina Wadud and I remember Rifat Hussain. I don't know whether she's still there, but there have been some very remarkable interventions by women in the field of Muslim family law. In the absence of female theologians, therefore, there developed a tradition of misogyny among male interpreters of Muslim law. Muslim women and feminists contend that it is not Islam but historical interpretations of Islam that must be subject to critical examination. Women's rights advocates, therefore, in my view, need to simultaneously uncover the coexistence of patriarchal legal texts within the Quran's spiritual and ethical vision. The voice of the latter is muted, yet it is unmistakably there, and it is a source of inspiration for all Muslim women who believe in the Islamic vision of equality between men and women. So, Muslim women's engagement with the text is a necessary first step towards redressing a tradition of misogyny within establishment Islam, and also to challenge the view that patriarchal or regressive Islamist positions are necessary Islamic, in quotes. Now, having said or made the above points, I want to just emphasize that all what I have said so far has much resonance with regard to Muslim family law legislation in colonial and modern India. In 1937, for instance, the Shariat Act overrode customary practice and sought uniform application of Muslim Hanafi law to Muslim women in British India, including the Islamic rights to inheritance, divorce, and property. Yet, as mentioned already, due to the restricted grounds for divorce available to Muslim women in colonial India under Hanafi law, the 1939 Dissolution of Muslim Marriages Act extended the grounds for divorce available to Muslim women in British India under Hanafi law by incorporating the provisions of the more liberal Maliki school of jurisprudence into Hanafi law. Hanafi jurists laid down that in cases in which the application of Hanafi law causes hardship, it is permissible to apply the provisions of Maliki, Shafi, or Hanbali law. The outcome of this 1939 legislation for Muslim women's divorce rights was noteworthy. And here I want to quote Rohit Dey, who in his article observes that the act was a radical piece of social legislation that gave South Asian Muslim women greater rights for divorce than those enjoyed by other women in India and Britain. Instead of placing women's rights and Islamic law as opposed to each other, which is also the dominant narrative in contemporary times, this legislation guaranteed women's rights by applying Islamic law. The 1939 DMMA, or the Dissolution of Muslim Marriages Act, challenged stereotypes of an immutably misogynist Muslim law beyond human agency or intervention. It also mirrored a Muslim modernity, wherein Muslim identity was not in contradiction, but very much in consonance with gender equality. Muslim men's recourse to unilateral triple talaq, which is again a very highly contested terrain and question in contemporary India, has been inferred as irrefutable evidence of Muslim legal and by extension cultural incompatibility with secular modernity. The practice of triple talaq does indeed exist to the great detriment of Muslim women's rights, dignity, and welfare. However, court judgments by Indian jurists affirm that triple talaq is not constitutive of Islamic legal canon. In his 1979 case judgment on divorce in Muslim law, Justice V.R. Krishna Iyer noted that, and here I quote, the view that the Muslim husband enjoys an arbitrary, unilateral power to inflict instant divorce does not accord with Islamic injunctions. Indeed, a deeper study of the subject discloses a surprisingly rational, realistic, and modern law of divorce. In another case judgment, which I want to quote here in 1979, Ruqayya Khatun versus Abdul Khaliq, Justice Baharul Islam and Justice D. Pathak held that in our opinion, the correct law of talaq as ordained by the Quran is talaq must be for a reasonable cause, that it must be preceded by an attempt at reconciliation between the husband and wife by two arbiters, one chosen by the wife from her family and the other by the husband from his. If their attempts fail, talaq may be effected. It is a popular fallacy that the Muslim male enjoys under the Quranic law unbridled authority to liquidate the marriage. So this is, part of the judgment which I just quoted. Unfortunately, triple talaq has transformed into an inflection point that works to accentuate Muslim difference, deepen the divide between Muslims and other communities, and reinforce Muslim exclusion. Such a framing also reflects what feminist historian Joan Scott terms as the mutually constitutive nature of gender and politics, that in this case forecloses the possibility of historically grounded, empirically anchored, and nuanced understandings of Muslim law as a contested domain in India and other parts of the world. And I want to conclude by just sharing that I was part of a major research project in the 1990s, which spanned Asia and Africa and the Middle East. And what came across very clearly was some of the points which the other speakers shared about, progressive law in North Africa, particularly Morocco, where groups such as Feminist Collective negotiated with governments and with legal authorities to craft, more egalitarian versions of Muslim law. And it was for South Asians, perhaps it was quite amazing and surprising to know that at least at that point of time, triple talaq was simply not there in Morocco. So they had negotiated, they had codified Muslim law, which was egalitarian and in keeping with the principles of equality, which is there in the major human rights documents. So I want to just conclude by again re-emphasizing the fluidity of Muslim law as a contested domain, and Muslim women's struggles to reclaim the narrative and to recraft law as more egalitarian and more gender just. So thank you very much. I hope I've kept to the time. Thank you.
Thank you, Dr. Seema Kazi. It was such a wonderful presentation. Now I would like to call Fatima Sahara to present your paper. Please unmute yourself and present your paper, Fatima.
Just a minute. I think there is one message regarding Dr. N. Nazani. So will she be allowed to present here because she is also wanting to present her paper? So after this one,
Yes,
after
ma'am,
this one,
I will, after this one, I will do the presentation, ma'am. Thank you.
okay.
Fatma, can you please unmute yourself and present your paper? I think there is some technical problem from their side.
Hello, ma'am.
Yes,
Hello,
yes,
hello.
Fatima, you are audible.
Yeah.
And
I'm confused that if you have called me or anyone other else,
No.
because in the list I'm the last one. That's why I'm sorry.
yes, yes. So we have reached the last one. Fatima, you can present your paper.
Okay, ma'am. Thank you. Share the screen. So my paper highlights how is. Am I audible, ma'am?
Yes,
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 you
you
are.
are. Please go ahead.
I think something happening here. I couldn't share my screen. So my paper highlights how Islamic feminists focus on legal reforms, particularly in marriage, divorce, and inheritance, where patriarchal readings of scripture have created systematic disadvantages for women. And let me go through my paper. Understanding Sharia law. Sharia law can be defined as a comprehensive system of divine law in Islam that governs both public and private aspects of Muslim life. It is viewed as the expression of God's commands covering moral, spiritual, legal, and social dimensions of conduct. Linguistic and religious meaning. The Arab word Sharia literally means path to water or the path to be followed, symbolizing a clear route to moral and spiritual fulfillment. In the religious sense, Sharia represents God's will as revealed to the Prophet Muhammad, as serves as a framework guiding Muslims toward righteousness, justice, and salvation. In essence, Sharia refers to the totality of divine ordinances governing every aspect of human life, spiritual, ethical, familial, and legal. Muslims believe it provides a code of living to harmonize personal faith with societal justice, aiming to ensure moral order and human dignity. What is Islamic feminism? Islamic feminism is a theological, intellectual, and activist movement seeking gender equality within an Islamic framework grounded in the Quran and Hadith rather than in purely secular fem- uh, feminist ideologies. In academic studies, it functions both as a hermeneutic framework and as a discourse of social reform, analyzing how Islamic texts and traditions can be reread to promote gender justice. Islamic feminism is defined as a form of feminism concerned with the role of women in Islam, aiming for full equality of all Muslims regardless of gender in both public and private life. Advocates reinterpret Quran and Hadith to challenge patriarchal understandings drawing on Islamic theology rather than rejecting it. Scholars such as Margaret Bertrand describe it as a feminist discourse that derives its understanding and mandate from Quran and seeks justice for both women and men through Islamic ethics. Stoning of Suraya. The 2808 drama film, The Stoning of Suraya M, is based on the true story of Suraya, an Iranian woman falsely accused of adultery and brutally executed by stoning in 1986. And let me move on to my paper, Patriarchal Overreach and the Feminist Reclamation of Sharia, analyzing Islamic feminism in The Stoning of Suraya M. The film's Stoning of Suraya critically exposes how religious leaders exploit Sharia law to consolidate patriarchal authority. They manipulate Islamic legal principles and religious rhetoric to justify violence against women, specifically honor killings to maintain their power structures. The leaders in the film, including the village mullah and officials, use religious language such as Allahu Akbar during the stoning, falsely claiming divine sanction for their brutal actions. For instance, a dialogue from the film illustrates this manipulation. The mullah states, "With each stone that you throw, your honor will return," signifying how religion is used to legitimize violence and reassert male dominance under the guise of religious righteousness. The leaders craft a narrative and frames women's shame and perceived dishonor as a threat to social cohesion. And they invoke Islamic law selectively, ignoring its broader ethical principles of justice and mercy. This reveals how they are reclaiming religion as a tool of patriarchal control rather than its true spiritual message. Throughout the film, the portrayal of these religious figures helps expose their fraudulent use of Islam to justify unjust practices, showing how they have distorted the religion to serve their institutional and personal interests. Islamic feminism, while applied to this context, would emphasize re evaluating and challenging the misuse of religious texts and authority. And Budud holds that Quran's message on sexual ethics is gender neutral and rooted in moral accountability that applies equally to men and women. She highlights that Quran's language is universal, never signaling out women for harsher sanctions. and insists the verse like Al-Nur 24:2 should be read within Quran's broader principle of equality, justice, not as justification for societal shaming or harsher punishment of women. Women in the film, such as Zahra, symbolize this effort. They attempt to resist and reinterpret religious narratives to oppose oppression and advocate for dignity, suggesting that a reform within Islam is both necessary and possible. This approach advocates for a reclaiming of Islam's authentic principles, resisting patriarchal distortions that justify violence and honor killings. To conclude, patriarchy in the film tries by exploiting Soraya's vulnerability as a woman, her economic dependence, social isolation, and lack of legal rights, while using fabricated accusations and communal enforcement to maintain control. The shocking stoning scenes forces viewers to confront how male-dominated power structures silence and ultimately destroy women who resist oppression. The film also critiques the Can I continue? And
Ma'am, you have to
ultimate
wrap up in another minute.
yeah, male-dominated power structures silence and ultimately destroy women who resist oppression. The film also critiques the capacity of societal institutions and the community members in perpetuating misogyny. In essence, Shawning of Suraya reveals patriarchy's fraudulent manipulation of religion and law to legitimize male dominance, exposing how it thrives on the weakness imposed on women by denying them agency, justice, and life itself. Thank you, ma'am.
Thank you, Fatima. Now I would like to invite the chair of this session, Professor Huma Yaqub, to share your remarks, please. Over to you, Huma
Okay.
Yaqub.
So, shall we take some questions first, or shall I just?
I didn't present.
Actually, your session is not in this one, so I'm being told that since there is a keynote session also, so like there is, so we can't adjust you in this particular session. Okay, I hope you understand. Okay, so we had some very interesting papers today, and I think in total we had 6 papers that were presented. So finally, although initially when we started, I think some of the paper presenters were unable to unmute, and that is why I thought that maybe only 1 or 2 presenters are there, but luckily everyone joined, and so there was full attendance, I should say, and very interesting papers that were there. And as the theme of this particular session has been very well thought of, and that is why all of these papers that were presented, they were essentially all about revisiting Islamic jurisprudence. And in that particularly, I would talk about this paper that was presented by Samane Uladi, and how she was essentially she was dealing with exploration of Muslim women in Iran, and like how she was talking about that Islam and gender, they are not paradoxical to each other, and that is essentially, I think, all of the papers were essentially dealing with that. What happened? So they are not opposite to each other, but rather it is the patriarchal interpretations that were essentially there because of this lack of female intervention or female interpretations. And that is why how there is this necessity to for female interpretation of Quran, and how things can be, or a female lens can be used to understand many of the verses of Quran, wherein, because essentially Allah is in Quran, whenever any male is addressed, it is simultaneously women, or woman is already addressed to. So there is nothing that how a woman is not treated secondary in any way. And I should say that there are two basic things that we should, when we are talking about egalitarianism, or when we are talking about Islamic jurisprudence with regard to women particularly, I should say that how this ritual of sai, okay, that is like how this we are remembering a particular woman, that is a Hajar, and her that particular action is repeated in Hajj when she is moving from Safa and Marwa. Okay, so that particular ritual of going, or 7 times, that ritual of undertaking that is remembering a woman essentially. So of course that shows the importance a woman plays in this the religion of Islam, I should say. And of course then even when we talk about that inheritance laws, okay, it is a woman who is essentially, when we see that as a daughter, and as a wife, and as a sister. Okay, so there are three ways in which a woman is essentially inheriting. But that is how we have to understand that the patriarchal view, or rather things which have not been elaborated upon. So that is the right intervention that we have to see into it.